Well, I'm very grateful. I intend to deal with three things. Firstly, the pleaded case and the submission and the findings below. Secondly, the law and new points. And thirdly, the POCA points that we rely upon. Firstly, dealing with the case as it was presented. Within ground one, of course, common law illegality, there's no dispute that we raised that. One of the considerations is the coherence of the law. And so our first submission is one has to consider the Proceeds of Crime Act's relevance, as was mentioned in Patel and Mirza, where you're considering the coherence with the civil and criminal law.
Did you argue that below?
Yes, my Lord, I'm about to come to the other points on where we've mentioned POCA below and in what context. What I don't say is everything that was said about POCA below is what I'm saying about POCA, but I do say it was raised in these ways. So the first is it was raised in that way, that it's part of the public policy considerations and issues behind that. So I'll give you the reference in a moment. Second point is that offences under the TBLA and LCCA were what was pleaded. The illegality is the offences under that Act, carrying on without a licence, which is set out in the pleadings on which the learned judge made findings that you are in breach, you are carrying on without a licence. Those are the ingredients of the offences that she sets out in her judgment at 42 and 44. Now, those offences under TBLA and LCCA, we refer to either as offences or in terms of illegality, which is just the word chosen for reflecting offences at times, in the following places. Page 166, paragraph 176D.
Well, I mean, it's really references to POCA that we're interested in.
Well, my Lord, POCA arises because we say criminal conduct has occurred. So I was just referencing...
I mean, yeah, we know that's your case on illegality.
I thought a pleading point was taken against me. I might be wrong. I thought a pleading point was taken against me about offences. It was clearly put as offences, illegality and offences.
My Lord, I am taking a point about the fact there was no finding of criminal offences and that pleading on criminal offences was struck out.
And my Lord, the references to illegality and or offences, and both appear in the pleadings even as they remained. The only reason that the word offences was taken out was what was being alleged was illegality on the basis of the offences. It was no necessity to plead it in terms of a criminal offence. You're not required in the civil court doing illegality to make that, to make a finding of an offence, rather than make a finding that you've committed the offence of it, that's the illegality. It's the illegality that had to be proven. But you have references to both. Paragraph 176D, firstly, in relation to the appellant's statement of case, as a result of the contravention committed an offence, page 166. 176D. Bless you. Page 149, paragraphs 116 to 118.
So page number again, sorry?
Sorry, my Lord, page 149. These are in the reproduced record bundle if you have that available, but otherwise electronically 149. What you have in 116 to 118 is that the carrying on a business was contrary to subsections 4.2, you're familiar with, is the offence. 17.2, because the 2019 law was being spoken about, that's the offence as well. TBLA version.
So page 149.
Paragraph 117 of the statement of claim. 118 was illegally continued to carry on this business. You have reference to the pleading of the offences. That is contained also in the closing, page 737 of the bundle, paragraph 151, also referring to the offences. And the judge made all the findings necessary that were of fact. You carried on the business without the licence, that's the breach of section 4.1, and it's an offence by section 4.2. There's not a Rizzler paper between them, or a cigarette paper between the two. And they were both pleaded. Third point is the public policy point, which my Lords, I think, just mentioned to me. That was before the courts below, and you can see reference to it in the Court of Appeals judgment, paragraph 41E, page 72 of our bundle. Court of Appeals judgment, paragraph 41E.
So page what's it?
Page 72, my Lord. not reflecting the established public policy in the Cayman Islands of advancing a culture of compliance reflected inter alia in the Proceeds of Crime Act and the Anti-Money Laundering regulations, and reference to the grounds of the appeal that refer to that.
So whereabouts do we find the Proceeds of Crime Act being put forward before the High Court judge as a part of the public policy consideration under the three Patel considerations?
That reference in the closing, that's to the Grand Court. So it's in the Grand Court closing, that's page 737151. Sorry, that's the offences. Sorry, my Lord, I don't have a reference if it's in the Grand Court. It's before the Court of Appeal.
Was it submitted to the judge that, as part of the public policy considerations, the Proceeds of Crime Act should be taken into account?
My Lord, I can't immediately answer. I know it's taken into account by the Court of Appeal, so it's on appeal to this court from the Court of Appeal. I can't go beyond that because I haven't looked beyond that.
Does that mean it wasn't?
No, it means I can't answer you now in the time I've got. I'll try and deal with that in my reply, and I'll check the position for my Lord. The point about a confiscation order was raised also in the appeal grounds, page 399.
And I'm sorry for interrupting you, but whereabouts do we find the appellant's submissions in the Court of Appeal as to the balancing exercise, saying, here we are, this is the Proceeds of Crime Act, offences have been committed under it, those offences should be taken into account?
No, my Lord, offences haven't been committed under the Proceeds of Crime Act. They've been committed under the TBLA and LCCA.
Potential money laundering offences being committed under the Proceeds of Crime Act.
That's the third element of my reliance on POCA, but just to take my Lord to where I was going, which I think answers partly the point, the confiscation order is referenced on page 399, paragraph 2.23.5 of the appeal grounds. Firstly, dealing with the Proceeds of 2.23.4, referring to the TBLA revision of the Proceeds of Crime Act as part of the overall public policy issues, and at 2.23.5.1, if the civil law takes back with the left hand condoning illegality as an unlicensed skilled money lender, allowing it to profit from its own illegality, and the next subparagraph, what the criminal law could give with the right hand by condemning via a confiscation order and by disgorging such profit from illegality would be harmful to the integrity of the legal system. It goes back to my point that this is not divisible from the common law illegality question, which had to consider the coherence with the criminal law. You see express reference to confiscation under the Proceeds of Crime Act as a consideration in that ground one element. Those are the references such as they are. I accept that I go further than the references do, but ultimately the court has to balance, turning to the law on the new points question, one has to balance the position between a matter which is raised, which can be dealt with in order to correct things, because there isn't finality, of course, until the appeal processes are complete. One has to bear in mind the points that are made in the authorities, and I'll just give you the reference, if I may, to the Primio Fund judgment, paragraphs 150 and 155, which essentially come to this. The question for the board is whether you have the factual findings necessary for the offences. Those are the TBLA, LCCA offences, yes. Question whether it's a question of law on whether the profit made is proceeds of criminal conduct. Yes, it is. You just have to read the statute. One doesn't have actual proceedings, one has the spectre of proceedings, the potentiality of it, and the consistency between the legislation and the criminal law and the civil law. And if, of course, matters were raised but not dealt with fully by courts below, that's not a bar to this court dealing with it fully. The ultimate tests are those set out in the authorities, Primio Fund being one of them, where there's a pure point of law and the proceedings wouldn't have been conducted differently. The allegations would have remained the same, the defence would have remained the same. We didn't have a licence, but we didn't carry on business. Where Jon's talking about illegality, of course, there's also occasionally the court's duty to raise it itself. That's considered in the authorities that have been referenced in the written cases, the point having been raised by the respondent. The Rampersad case, the court considered illegality despite it not having been pleaded or argued below, because it was an issue of law the board was bound to raise. That's per Lord Leggett in the majority, Rampersad, page 2984, paragraphs 21 and paragraph 22 over the page. The Nature Resorts case, which the respondent relies upon, was one where this court considered of its own motion whether to raise illegality, hadn't been raised on the appeal or below. But as a result of having no factual findings about it at all, no disclosure exercise, it was procedurally unfair for the board to go any further with it. So that's the extreme ends, which this case is not. And then you have this case where we submit respectfully the matter is one of law that needs to be considered in light of the findings of fact that there was offences committed, the illegality being the offences which are equally relevant to criminal conduct under POCA. Now, the third element is this, very briefly, that firstly, the confiscation regime under POCA, one only needs to consider section 69 in part 3, that's confiscation orders. Criminal conduct is conduct which constitutes an offence in the islands and benefit from that conduct if you obtain it as a result of or in connection with the criminal conduct. We've referenced in our case several cases on licensing where the criminal courts in this country, and indeed the Supreme Court, I think, in this country in one of the cases, have dealt with unlicensed carrying on a business and the proceeds of crime legislation. And the result is that if the offence is carrying on the business rather than the not having a licence, which is entirely this section, section 4.2 and the TBLA version, it's the carrying on of the business that's prohibited, which is why the contracts aren't illegal under them. That is criminal proceeds, and it falls to be confiscated under the regime, which is aimed at preventing gain from crime and ensuring that one has to show that crime doesn't pay and to take those wrong to let them retain the proceeds. And reference to that in this court's the Supreme Court in Ahmed case, paragraph 38, page 2604 for the aim of POCA. In terms of civil recovery, confiscation requires criminal proceedings to be brought. There obviously aren't any at present, but that doesn't mean there wouldn't be. The whole point of coherence is one has to deal with what the law says as a global whole. There could be criminal proceedings tomorrow. It can't be based on that vagary as to whether or not illegality at common law is or isn't available. So those cases demonstrate the applicability of POCA to licensing offences where there's carrying on a business without it, several of those cases there. And then under the Cayman law, the proceeds of crime law, for the civil recovery, the same references, this time it's section 77.2 and 78.1. Conduct is unlawful if it's unlawful under criminal laws, and regardless of whether proceedings have been brought for an offence. Civil recovery order available to the Director of Public Prosecutions.
So what page number is that?
Sorry, my Lord, that's page 977. I'm sorry I'm taking this at speed. But page 977, section 78.1, and the preceding provision 77.2 is regardless of whether there's criminal proceedings or not. The obligation on the court is to make the recovery order in respect of recoverable property. That obligation shall make is section 96.1, page 986. And recoverable property is defined in section 123, page 1001, as property obtained through unlawful conduct. So the submission on that is, of course, the risk is of dissipation. If a civil court requires proceeds of crime to be given to the offender, particularly when they're not in the jurisdiction, for that money to be restrained in any way, it leaves the jurisdiction, then you have the problem of dissipation for obtaining a civil recovery order subsequently for the same criminal proceeds. And the third part of our reliance on POCA is the money laundering aspect, which goes to the point raised in the cases about enforceability, where you're compelling a crime to occur or condoning a crime to occur. The definitions that are relevant there, it's a shorter part of the Act. Section 144 has much of the definition. Section 1442, criminal conduct is conduct which constitutes an offence in the islands. And
Again, the page number again, please.
Sorry, my Lord. 1016. 1016. Section 144(2), subsection 2, criminal conduct, subsection 3, you benefit if you obtain criminal property constitutes a person's benefit from the criminal conduct. And the offences that are relevant are section 133 and 134, page 1006 and 1007. Criminal offence of converting or transferring criminal property or removing it from the islands, or being concerned in an arrangement which someone knows or suspects facilitates the acquisition or use or control of criminal property by another person. And we submit not only would money laundering offences be committed by the respondent receiving, they would more importantly be committed by the appellant in giving. And a civil court compelling him to undertake activity which he knows or suspects results in the proceeds of crime of the unlicensed business carrying on illegally would be entirely incoherent with the POCA legislation, which renders that a criminal property which is liable to process of crime action. And that is the result in relation to the cases. While I don't have time to deal with them, the court will note that you have there the cases that set out how the courts have dealt with POCA and licensing. And it is sometimes referred to as harsh. Of course, a disproportionate order under POCA can be subject to that.
There are rather deep waters here, which we don't have the assistance of a local court interpreting its local legislation on. For example, I forget the name of the case offhand. I don't know if Lord Hodge sat in it, but we've had cases in this court to do with people carrying on an employment without having the appropriate license. And an attempt was made to deprive them of the earnings that they had obtained over the peace, and that was met by an A1P1 objection. Now, I dare say there would be, well, who knows? It may be under the law of the Cayman Islands there would be a constitutional objection to disproportionate recovery.
My Lord, obviously with A1P1 you have property, you have to have a possession. There'll be a real question, I suspect, over whether there's any argument that Abarbanel could raise that it had a possession, having a right to recover under an agreement, etc. And the distinction...
Well, it's got a contractual right, that's a shares in action.
My Lord, there's complicated authority on whether it amounts to possession for the purposes of Article 1, Protocol 1.
Well, I mean, I'm not wanting to argue the toss about it just now. The only point I'm making is that this is not a transparent issue, and it's one you're relying on UK law. We're dealing with a Cayman statute. We don't have the views of the Cayman court. We don't have the DPP of the Cayman Islands involved in these proceedings.
My Lord, we don't. But I make 2 points. One is it was raised below, not as fully as I elaborate upon it, but it was raised. It hasn't been addressed, or that it wasn't addressed at length. It is addressed to some extent, but it isn't addressed at length. Can't be laid at the door of the appellant in terms of correction if there's error in the way it's been approached. But more importantly, that it has to be addressed if one's thinking about the Patel and Mirza question of illegality, because the whole two points behind it are: one, don't profit from your crime, and two, coherence of the law. For this court to be invited by the respondent to shut its mind to the effect in POCA would not be satisfactory, and given particularly that we don't know what the position might be in terms of POCA in relation to these parties at any point. Just to ignore it, despite its clear significance, would cause difficulty, we submit.
Was both the confiscation element of POCA and the money laundering element dealt with below? I mean, the references you've given are just so fleeting that I would immediately assume that POCA is just talking about confiscation orders.
Well, my Lord, it's raised where it is. It's dealt with by the Court of Appeal to some extent, in the way that it does.
On money laundering, is it?
They refer to it in the paragraph I mentioned to money laundering and the public policy behind that. Right. When dealing with common law illegality, We submit they don't then give effect to that. They don't use that problem and grapple with it in the way that needs to be. But that is what is there. I can't point to anything further in the Court of Appeals judgment.
Well, was it submitted to the judge that a person commits an offence if the person transfers criminal property? And did the judge make any finding that there would be such an offence and that the property would be criminal?
Does my lord mean in relation to the plaintiff or the defendant?
Well, your client is alleging illegality on the basis of money laundering offences. The first money laundering offence you referred to is section 133, which is a person commits an offence if that person transfers criminal property. So you have to have a decision as to, and first of all, an argument that it is criminal property, and then a decision that it was.
Well, A, we say the law is clear, it is criminal property. Once the judge has made the findings that you've committed offences, you've breached the law, which is the offence. Section 4.2 is pleaded, Section 17...
I wish it was that simple, frankly, but anyway, not to worry.
The answer to His Lordship's question is that wasn't submitted, but you say the components which would support that submission were there.
Yes, I say the facts are there in terms of whether this court can properly deal with it. The facts are there to deal with that. What I accept is that there's not a decision about the future, but I wanted to make this point, that I thought my Lord's question was posited on me saying in the past there's been money laundering. That's not my submission. My submission is one has to look at the coherence of the law. If this court were to enforce, what does that amount to in terms of money laundering offences? Because the original offences are criminal conduct, that's why Hawkins engaged, and then its consequences include the money laundering offences. And my Lord, I've transferred.
Yes, you've not got much of your prior time left. Very well, thank you, Mr. Rule. We're going to adjourn for a short time to take stock of where we are and what we need to hear you on, Mr. Brown. It's going to take a little longer than usual because we have to make contact with Dame Janice, but we will be back as soon as we can. Well, Mr. Brown, we've decided that we don't require to hear you on the second issue that's been argued, that's to say, ground 3. We take the view that the matter's been raised too late and not in sufficient detail for us to decide it. So what we need your assistance on, obviously it's a matter for you, but primarily we'd welcome assistance on the issue about Section 23 and whether we should be distinguishing or declining to follow the judgment of Mr. Justice Knox in the Chase Manhattan case and the Patella-Mercer balancing exercise.
I'm grateful, my lord. So, my lords, my ladies, I will address matters in that order then, but I wonder whether I might still start with the overarching submission that we had planned to, and this is basically on the question of the importance of upholding contracts freely entered into. And of course, this was, and I don't think there's any dispute, a valid contract entered into by the parties, subject to the question of illegality. It was a loan agreement and charges entered into between a sophisticated individual and a company, concluded after he took legal advice. The Grand Court and the Court of Appeal found the contracts were not prohibited by LCCA or TBLA, even though the licensing agreements were breached. Now, of course, that is no longer challenged. The original findings, there was no statutory illegality, is no longer pursued before you, which we suggest is very important, and I will come on to explain the relevance to both the two questions that I will come to as to Section 23 and common law illegality. But the two overarching points that I would make at this stage concern, as mentioned, the importance of upholding contracts. I'd just like to show the board two pieces of dicta at the outset. The first is in the bundle at 3038. That appears to be a bad reference. Yes, so 3069, this is the decision of Devlin J. in St. John Shipping Corporation and Joseph Rank Limited. And in the bottom of the page, we see the judge cites Lord Wright, so it's about 8 lines down from the bottom, on page 3069. Nor must it be forgotten that the rule by which contracts not expressly forbidden by statute or declared to be void are in proper cases nullified for disobedience to a statute is a rule of public policy only, and public policy understood in a wider sense may at times be better served by refusing to nullify a bargain save on serious and sufficient grounds. It may be questionable also whether public policy is well served by driving from the seat of judgment everyone who has been guilty of a minor transgression. Commercial men who have unwittingly offended against one of a multiplicity of regulations may nevertheless feel that they are not thereby forfeited all right to justice and may go elsewhere for it if courts of law will not give it to them. In the last resort, they will, if necessary, set up their own machinery for dealing with their own disputes in the way that those whom the law puts beyond the pale, such as gamblers, have done. And the other dicta, just to show you briefly, we have cited in our written case at paragraph 61, and this is the board's decision in SR Projects against Rampersand 2022 UKPC 24, and we can find the judgment in the bundle at page 3008. And in this part of the board's decision, Lord Leggett, with whom Lord Lloyd-Jones and Lord Stevens agreed, was dealing with the question of common law illegality. And what the board mentioned in paragraph 86 is of a similar point. And we see there that the board quotes from Sir George Jessel in Printing and Numerical Registering against Sampson. It must not be forgotten that you are not to extend arbitrarily the rules which say that a given contract is void as being against public policy. Because if there is one thing which is more than another public policy requires, it is that men of full age and competent understanding shall have the utmost liberty of contracting, and that their contracts, when entered into freely and voluntarily, shall be held sacred and shall be enforced by courts of justice. Therefore, you have this paramount public policy to consider, that you are not likely to interfere with this freedom of contract. So those are just the introductory points.
Before you leave that,
Yeah.
it's interesting, if you go over the page, the top of 3009, the availability of criminal sanctions is put forward as a reason for enforcing the civil contract rather than for not enforcing it, on the basis that you let the contract take its course. If criminal authorities wish to take action, that's a separate matter for them.
My lord, yes, and that would fall when you're dealing with common law equality with the first of the trio of considerations, whether, and this was what was found below, that the criminal sanctions are sufficient to deal with the policy of the statutes. You don't need to go further and take the very extreme step of finding that contracts are unenforceable. So those were just the introductory remarks, my lords. And I will now just briefly move on, if I may, just to cover the purpose of the statutes, because that is a point which is relevant both to section 23 and also to the question of common law illegality. So I'll deal with that, particularly because my learned friend didn't take you once to the judgments in Esso or of the Chief Justice or of the Court of Appeal. And I think it would be important that you've seen some of the decisions, particularly on the question of what the purpose or underlying policy of the statutes were. And I'll then go on to Section 23 and to common law illegality. So first then, just to show you ESSO at first instance, and I'll then take you to the Court of Appeal decision in ESSO before I move on to the Chief Justice and Court of Appeal in these proceedings. So we start then with ESSO at first instance, and we see that, if I just make sure I've got the correct reference, give me 1 second. So if we can please turn to page 1532, we see towards the beginning of Murphy J's judgment at first instance in ESSO, so this is page 1532, that the judge starts by referring to the Memorandum and Objects and Reasons, which was published with the original 1971 Act. And I believe you may have been shown this already, but I would just ask my lords to read what's written in the Memorandum of Objects and Reasons, which is line 30 down at the bottom of that page. And then overleaf at the top of page 1533, the judge comments, having quoted from the memorandum, as is apparent indeed from recent unrelated litigation in this court, the main purpose of the legislation is to empower an administrative tribunal to screen foreign-controlled companies that wish to carry on business in the islands. And then if we move on to page 1538, the judge then deals with TBLA. So at the top of 1538, as one of my lords mentioned earlier, the judge refers to the fact that TBLA is clearly a revenue statute. It applies to all businesses, not just foreign or controlled companies. Qualifications, skill, or financial stability are irrelevant. If a trade or business is mentioned in a schedule, the relevant fee must be paid annually. The board is obliged to grant a license unless certain conditions exist, which include the fact that the applicant is a company to which the LCCA applies but holds no LCCA license. And then for completeness, we then finally move to page 1562 in ESSO. And in the middle of 1562, Murphy J, having cited the Australian High Court's decision in Yango, we see at line 15, he refers to the...
Which page? I'm so sorry.
Forgive me, it's 1562.
1562.
And we see, having cited Yango above, at line 15, the judge says that in Yango, Mason J focused on the object of the legislation. He concluded that in regulating the carrying on of banking business in Australia, the Act did not do so as a means of protecting customers of or depositors with banks, but as an element in regulating the Australian economy, including regulating the grant of authorities to foreign banks. The statute's primary purpose was not to define and regulate the banker-customer relationship. And then Murphy J says, I make the same distinction in the present case. In regard to the stated objects of LCCA, which of course have just shown your lordships, and its provisions, it is clear that it's aimed at screening foreign aspirants wishing to do business in the Cayman Islands. Thus, the Section 11.3 criteria focus on the nature of the applicant and the needs of Caymanians of the Cayman Islands. What LCCA does not do is to regulate the carrying on of business by foreign companies once in the islands, in the sense of regulating their commercial activity and their contractual relations.
The dictum just below that of Justice McHugh in the case of Nelson may be relevant also.
Yes, I'm grateful for my lord, and that goes back to some of the previous discussion. Parliament almost invariably provides mechanisms for dealing with breaches of its laws. And of course, in this scenario, there is a mechanism, there is a criminal sanction attached. And we'll come on to the fact that there is Section 23, which ensures that there is certainty, there is no contractual illegality. So those are the key points in the first instance decision in ESSO, which deal with the question of the purpose or underlying policy of the statutes. I just want to quickly show you, if I may, what the Court of Appeal in ESSO decided on the same point. And if we turn, please, to page 1579, we see about 2/3 down 1579 at line 30 that George's J.A., given the decision of the Cayman Court of Appeal in ESSO, explains that Murphy J. gave a comprehensive judgment, and he then cites the same point about the memorandum of objects and reasons at line 35, which I'll show you in a moment. And then on page 1585, and this goes to the point my Lord Reed made, 1585, we see that the judge there says the underlying purpose of the control law is adequately served by treating the prohibition as one attaching to the carrying on of business and not to the invalidation of contracts made in the course of carrying on such business. The law was enacted to empower a statutory board to control the level of participation in business by persons who are not Caymanian. There is no apparent intention to protect a particular section of the public who would be liable to exploitation unless some checks or balances were put in place, etc. And then we see at line 28, arguments may be advanced that transactions which may be neither void nor voidable may nonetheless be unenforced by the instance of a party who has acted in breach of the law. Whether this is so or not, the section does not indicate the legislature did... Sorry, let me start that again. The section does indicate that the legislature did not intend to make illegal specific contracts made in the course of carrying on a business at a period when there is no licensing in force. So we see from those judgments that the statutory purpose, as found by the Grand Court and the Court of Appeal in ESSO, was relevant to their decision on whether there was illegality. And then just finally, to take you to the decision of the Chief Justice in the present case, we have in the key documents bundle at tab 12 at page 46, the decision of the Chief Justice at paragraph 79 to 87. And just to save time, I'll just mention that essentially what the Chief Justice did was to rely upon the dicta in ESSO that I've taken to you as to what the statutory purpose was. She followed the decision in ESSO and in fact found it was binding upon her. But importantly, at paragraph 91, which I'd ask my lords to turn to, and my lady, at page 48 of the bundle, the Chief Justice addressed the argument that the changes to section 11 sub 4 had changed the purpose of the statutes. So we see at the bottom of page 47, paragraph 90, the judge quotes section 11.4, and we see over leaf at the top of page 48, the judge underlines subsections F to J, which was the subsections that were subsequently added. And the Chief Justice mentions at paragraph 91 that those provisions were introduced in the 2007 revision, but she concludes at the end of 91 that the focus of the criteria set out in section 11 remains, as stated by Murphy J., on the nature of the applicant and the needs of Caymanians and the Cayman Islands. At 92, Mr. Merrin has not persuaded me that the Court of Appeal erred in its assessment of the policy behind the provisions of LCCA, and that I should depart from what is a binding precedent. So the judge considered the point now made that somehow the policy had changed subsequently to enactment in 1971.
Can I ask you something that appears from the ESSO case is that every time that ESSO asked for a license, it was granted on a backdated basis, so that they were carrying on business at a time when there was not in fact a license, but subsequently a license was issued which covered the period of that trading. Now, how does that affect the argument?
One point it does affect is the suggestion that I'll come to in due course that these were offences per se under the criminal law. Because if you can retrospectively obtain a licence, it highlights that these were not criminal offences per se. You could enter into a loan agreement without that being a criminal offence per se. The fact that you can retrospectively obtain a licence would immediately prevent any criminal prosecution. The problem, however, with my learned friend's argument, he suggests that this is a complete answer, that if you need to obtain a licence retrospectively, you can just do it. But the problem with that is that that's within the complete gift of the board. They have a complete discretion, they don't have to give reasons, you may not be able to obtain the licence. Just to complete then running through the cases.
How would that work out in the criminal case then, insofar as if there was a prosecution, and are you suggesting then there would be a defence that the prosecution having proved that the board wouldn't have granted a licence if one had been applied for?
Honestly, my lord, this is all new. There's a problem that we're facing, that there was, as I'll come to explain in due course, there was no allegation that an offence was committed by us, although of course that now is water under the bridge because the board has decided not to deal with POCA. It's not something we've had to grapple with thus far. And just for completeness then, the Court of Appeal's decision in the present case, which is the judgment of Sir Jack Beatson, we can find in the key documents bundle at tab 7 at page 77, and we see at paragraph 50 onwards, the Court of Appeal considered whether the Chief Justice had erred in her assessment of the purpose and policies of both statutes. And then we see at paragraph 61, the Court of Appeal concluded that the Chief Justice had not. And then at 62, Beatson J.A. explained why he agreed with the Chief Justice that the changes to section 11.4 did not change the underlying policy. So we suggest that it's clear from the decisions both in ESSO and both of the Chief Justice and Court of Appeal in the present case that the underlying policy of the statutes is essentially economic protectionism. It is to ensure that Caymanians don't face unfair competition from foreign majority-owned businesses. It is not about trying to protect individual consumers, for example, or others who contract with those companies. And that's LCCA. Of course, TBLA is simply to raise revenue, as one of my lords mentioned earlier. So that's just very briefly the decisions below, particularly as relevant to public policy, which then in turn affects the meaning of section 23 and the issue of common law illegality. Can I just briefly, before moving on, show my lords and my lady some of the materials which are relevant in the event that the board wishes to go to them? So the bundle in 850 is the copy of the Memorandum and Objects of Reasons of LCCA. So we see that at page 849 is the title page of the Act, and then we see it's been published at page 850 with the memorandum. At present, it is possible in certain cases to avoid the effect of the work permit law by forming a local company and conducting a business through which, in the eyes of the law, is resident in the islands, although it may be in the full control of foreigners. It is sought to exercise some control over this situation by requiring all companies doing business locally to be under the control of local people or be licensed to carry on business here. And we then see at 852 the passage that my learned friend showed you, which is the title above the Act, a law to prohibit, save under license, the carrying on in the Cayman Islands of local businesses by companies which are not under Cayman control. So we suggest that those are materials which are admissible because they have been published with the Act. And then page 1144, we see the memorandum for the TBLA as enacted in 1971, which very clearly shows this is a revenue statute. And we see in the middle paragraph, the function of TBLA is to raise a certain amount of revenue and in relevant cases to exercise hygienic control over premises.
May I have that page number again, please?
It's 1144.
Okay.
And I don't know whether this will be something that the board will find of assistance. Of course, Hansard has rules, pepper and heart, as to whether it's admissible or not. But in case the board wishes to see Hansard, we can find the second reading of LCCA at page 4247. And the Hansard provisions, which record the debate led by the minister in charge of the bill, Benson O'Banks, are exactly along the lines of the memorandum which I've already shown the board.
I've got the wrong reference. What did you say Hansard was?
It is 4247.
42, thank you.
And then at 4249 is the second reading for the TBLA. And that again very clearly shows that the purpose is revenue raising. Now we suggest that looking at the provisions of the statutes and the memorandum and Hansard, it is very clear that the purpose of these statutes was not, as I said, about somehow protecting consumers or Caymanians from the particular business activities of foreign-owned companies. It's not about some form of regulatory process for money lenders. There's simply nothing in the statute which turns this into some sort of financial regulatory act. And as mentioned, my learned friend didn't even take you to essay, so he hasn't engaged with the reasoning of the courts below on the purposes of the legislation. And what we would finally suggest on this point is at times what my learned friend in his written submission strayed towards is giving evidence on what the board would or wouldn't do in terms of trying to license certain companies. There's been no evidence, a point that was raised earlier, as to the practice of the board, as to whether the financial activities or transactions of these companies are monitored. So some of the points which my learned friend relies upon really should have been raised at first instance with evidence given if they want to advance a case that this really was some form of active regulation. So those are just some of the introductory remarks on the purpose of the Acts. And unless I can assist you further on those points, I'll move on to the interpretation of Section 23.
Yeah, I'm still, and I may be missing something here, I'm still puzzled about the statement that you've made to the effect that we aren't dealing with any form of criminal offences here. Because what are we dealing with then?
So first and foremost, we're dealing with a licensing requirement.
Yeah.
And a breach of the licensing requirement, which of course is the basis of the finding of the Chief Justice that the respondent should have had a licence and didn't. There's a separate question as to whether a criminal offence was carried out, and you might think one follows the other, but what the Chief Justice decided was on the civil standard whether a licence was required. What the Chief Justice didn't do was decide on the criminal standard was an offence committed. And I can take you through some of the more detailed points, but in short, there's nothing in her judgment that says a criminal offence was committed, and I can show you that these points were struck out. But I think, strictly speaking, this question of criminal offence goes only to the new arguments on POCA, which the board has decided it won't be addressing. I don't believe that a criminal offence has been referred to in arguments on Section 23 or on the general common law arguments.
I'm just thinking aloud. Obviously, she didn't have jurisdiction to rule on whether a criminal, she didn't have jurisdiction to determine in law whether a criminal offence had been committed because she's exercising a civil jurisdiction. She can't preempt what a criminal court might decide.
Exactly, my lord. And that's one of the
Was that her thinking?
I'm sorry, my lord.
I'm wondering if that's perhaps her thinking.
Yes, we suggest in a written case that she very carefully avoided making any findings as to whether an offence was committed, because that's just not the role of the civil courts. And the allegations put before the court were on a civil standard. And you can see in the judgment, she obviously found that it was an arguable case that the respondent had, that it was not carrying on business. In the judgment, she sets out the various arguments that were advanced as to, I can find it if it's useful, as to, if I can just find my bundle, I'll just take you to it very briefly. It's in tab 12 of the key documents bundle.
So sorry, just before you go there.
Yeah.
So when we're talking about illegality in this case, I had assumed we were talking about criminal illegality, but you're saying it might be illegality in the sense of being breach of a statute that is not necessarily criminal. Is that right?
My lord, yes, because you can have a statutory requirement that imposes an obligation under statute, for example, to obtain a licence, but does not then in turn attach a criminal sanction to that. I don't think ultimately this is a point relevant to the issues that I now have to deal with, but I think it's given the board's not dealing with it, I think this is an irrelevant point. But if I can just show you what the judge found.
Yeah, I mean, it's a point of wider significance. I mean, a civil court can't determine guilt of a criminal offence.
Absolutely, my lord. And that was one of our key points as to why we would suggest that the Pocket case must be flawed, because it's not the role of the civil courts to predetermine the outcome of as yet non-existent criminal proceedings. It would be entirely improper. We've had no criminal charges laid against the respondent. We've had no indication that they would ever be brought. We have no specificity of what the charges would be. For the first time, a learned friend in submissions talked about what the mens rea of the offence would be.
Well, in a way, if there were, the point would be even clearer. I mean, if there were actually proceedings in a criminal court being brought against your client, then the civil court would be even more careful not to express any view about the guilt or innocence.
My lord, yes, and ordinarily, as a matter of case management, the civil proceedings would probably be adjourned pending the outcome of the criminal proceedings. We see that
thinking in terms of an allegation, proceedings based on fraud, and which is a criminal offence, and certainly you may make a finding that fraud has been committed, but you're certainly not finding that a crime has been committed.
My lord, yes, and of course there might be a higher standard of evidence required to show fraud on a civil basis, but still it would be on the balance of probabilities rather than based on the criminal standard. And if I can just briefly show you the judgment of the Chief Justice, which is tab 12 in the key documents bundle.
Yep.
And we can see when dealing with this point, she set out the arguments for and against whether the respondent was carrying on business. So from page 37 onwards, which is paragraph 46 onwards, the Chief Justice sets out the case law on what carrying on business means. And just to short circuit to the end, at page 41, paragraph 64, the Chief Justice concludes at paragraph 64, in summary, the conduct in issue must occur on a repeated or continuing basis. The cases do not establish a threshold as to how many activities here the making of loans would constitute a sufficient repetition of facts, or for how long the period of activity must go on to be characterised as continuous. That is a question concerning the facts of the case.
I see. Yeah, so there might not be enough loan transactions. There might or there might not be enough loan transactions to constitute the carrying on of the business.
Exactly.
But one isolated loan wouldn't constitute carrying on a business on the authorities.
Exactly, my lord. And that's consistent with what we see at paragraph 65 below, where the Chief Justice summarises the case that we advanced at first instance as to why we took the position that there was no carrying on of the business. We didn't deny the loans were made, and we see various facts that there was no employees, no website, all of the requests for loans were unsolicited, there was a small number of loans. And then the Chief Justice at paragraph 66 contrasted that, the fact there were 6 loans, still a quite small number, security was a right required for the loans, and then at 67, the Chief Justice says, in my judgment, these facts establish with the degree of system and continuity the decided cases say must be present. We see at 66, just to go back, having considered the totality of the evidence, the judge doesn't suggest she thought our case was hopeless. So if criminal proceedings were ever brought, of course, no doubt we would be arguing, well, in fact, you've not proved on the criminal standard that we were carrying on business within the meaning of LCCA.
Yeah, I'm just trying to pinpoint what the illegality is. I mean, it's, in almost all past cases, the illegality is a crime or a civil wrong, but you also, you know, a tort or something of that kind. But your case is here, it's neither. It's just a bare breach of statute.
Well, if you look at the judgment of the Chief Justice,
Yeah.
she doesn't make any finding that a criminal offence was committed.
Okay.
And so it follows from that, likewise with the judgment that follows from the Court of Appeal, that they found that there was a breach of statute, and that was the illegality, potential illegality, of course, because in due course they found there was no illegality.
Do you have a reference to the pleadings that were struck out?
Yes, my lord.
And do you know why?
So it's in the electronic bundle at 162.
I mean, they're not saying there's no illegality.
No.
When you just before we got to this, you just said, oh, a finding of no illegality. Not finding there's no illegality. The finding that the contracts are enforceable despite the illegality.
Forgive me, I should have said no statutory illegality. A shorthand being for the fact that the statutes are still enforceable, notwithstanding the breach of the statute. Because the law distinguishes between, if I may say so, the fact that you might breach the statutory provision.
Yeah.
It doesn't mean that the contract is unenforceable. So
No,
there's
I see that.
Yes.
Yeah.
So there's
I mean, it's directed to the carrying on of the business rather than to invalidating the contracts is a separate issue.
Yes.
If that's what you're meaning.
Yes, and so here what the court's
But
decided.
we're not saying that there's no illegality, i.e. no breach of statute. Clearly they didn't have a licence. That is a breach of a statute. That is illegality by statute.
Well,
It doesn't, on your argument, mean that the contract is unenforceable.
well, my lord, two types of illegality.
Yeah.
One, the shorthand being statutory illegality.
Yeah,
The second being common law illegality.
right.
The courts here found there was no statutory illegality. They challenged that point and they abandoned the appeal against it. Well, that was a finding. Sorry, my lord.
Do you mean by that the contract was not struck at by the statute? Is that what you mean?
Exactly. I'm taking this too quickly. Yes. So the finding there was no statutory illegality is that there was no express or implied prohibition against the contracts.
Yeah.
So forgive me, I've been taking that shorthand.
Yeah.
You're quite right, my lord. Of course, on the finding of the Chief Justice, there was a breach of the statute because there was no licence.
Yes.
Yeah.
So
It's partly the problem that identifying the illegality is a first issue. We then have to deal with the effects of the illegality. The effects may be either dealt with by statute or by common law. And you're saying that what we've got is we've got an illegality by statute, but actually the statute, the effect of it, was not dealt with so as to make the contract unenforceable by the statute, and you would say, nor by the common law.
My lord, yes. And of course, with section 23, it goes further because the intention of Parliament was to expressly save enforceability of the statutes. And I'll go on to develop.
Yeah. Sorry, Patrick. I think you.
yes, the pleadings, quite a lot was struck out, or was it edited out by the appellant?
So I would have to take instructions, but these were amendments to the pleading made by the appellant themselves. So when I say struck out, I mean struck out by amendment.
Yes, so ultimately not put forward. It wasn't a decision made by the Chief Justice that this could not go forward.
Exactly, my lord.
No, that's fine.
I'm told that's correct. The key parts to show you that were struck out, even if there might be some earlier references to offences, are critically at page 173 of the bundle. And we see this is the prayer for relief as to what declaration the claimant, now appellant, was seeking. We see under the heading, and the plaintiff claims, at the bottom of sub 1, determination of the following questions of fact and or law and or construction of the documents arising in this cause and or declaratory orders and or binding declarations of a right to give effect to that. And then we see, for example, the money lending allegation that was ultimately dismissed. And we then see over leaflet 174 at sub D, in accordance with section 17.2 of TBLA, and we see at the end, the original allegation was the defendant committed an offence, and that has been struck out by amendment,
Yes.
replaced with thereby acted illegally.
Yes, it's a bit easier to understand now we've actually looked at the Chief Justice's judgment, because clearly the facts were not altogether straightforward. She's approaching it with a civil judge and saying, on balance of probabilities, I'm satisfied that they required a licence and they didn't have one. But it doesn't necessarily follow that there would be proof of guilt to the criminal standard.
Exactly, my lord. And obviously the rest of the page at 174, you can see further allegations of the defendant committing an offence are struck out by way of amendment. So that's the basis on which the trial proceeded, which explains, in part at least, why there were no finding of criminal offences. There was no evidence put forward, and I would suggest that my learned friend's submissions on this were misleading in suggesting that there were in fact findings of a criminal offence by the Chief Justice, because you just can't see that in the judgment. So unless I can assist you further on this issue, shall I turn now to section 23?
Yes, certainly.
So may I start with a simple point? Of course, in our written case, we've set out some arguments in detail on this point, so you can find that in our written case at page 660, which is paragraph 97 onwards. And can I just start with a simple point, which is this. Parliament saw this coming. Parliament must have foreseen that a party would try to get out of its contractual obligations by relying on a licensing breach. That is the fact pattern that we see in the English cases as at enactment in 1971, as shown by the extract from Holsbury's I will come on to show you. They must have been trying with section 23 to provide legal certainty in that scenario. And that, we would submit, consistent with one of my Lord's comments this morning, is why the provision starts with the words, for the avoidance of doubt, it is hereby declared. Just on a pure textual reading, it is trying to provide legal certainty. And that is
also, it's interesting, for the avoidance of doubt, I mean, it's predicated on it being possible to infer from the other provisions of the statute that it's not directed towards and is not intended to result in the invalidation of contracts carried on, contracts entered into where a business is being conducted without a licence.
My Lord, yes, and the courts both in Esso and in the present case found that that was not the intention of Parliament in enacting statutes consistent with the purpose of those statutes. They then go on to deal with section 23, but their first point, based on what I described as statutory illegality, was there was no express or implied prohibition on the contracts themselves, even before you get to section 23. So in a sense, section 23 is belt and braces, which really does beg the question, why on earth would the Cayman Parliament be trying to distinguish between a nuanced position that somehow common law illegality might still apply, even though what they're trying to do is to provide legal certainty? And we would suggest, and I'll come on to this point in due course, in terms of the settled position in the law, that we've found no Cayman judgments before Esso or after Esso where any party has tried to bring the type of claim now levelled against the respondent. It appears to be the case from the lack of any Cayman judgments that Section 23 was successful in providing the certainty to prevent the type of litigation that's now been brought, to prevent the type of legal uncertainty that would happen if every party who inadvertently failed to apply or renew their licence suddenly found that all of their contracts might be unenforceable unless you went through court proceedings under Patel and Mirza. So that's our simple point that Parliament saw this coming. I now have 5 points to address you in more detail. And the first is, of course, a question of statutory interpretation is what we're dealing with. What did Parliament intend? And I won't go through the authorities which the board will be very familiar with. I would just like to emphasise 2 points, if I may, just by reference to our written case. So page 641 of the bundle, which is tab 4 of the key documents bundle, this is our written case, and we see at paragraph 21, we've cited Lord Hodges' judgment in R.O., and we see the quote there, if it's convenient to take it in my written case, at the bottom, that there is a constitutional reason for having regard primarily to the statutory context. Citizens, with the assistance of their advisers, are intended to be able to understand parliamentary enactments so that they can regulate their conduct accordingly. They should be able to rely upon what they read in an Act of Parliament. And then the second point, just to highlight very briefly, is just below at paragraph 23, and that is the dicta of Lord Bingham in the decision in R. Quinterville. And we see there, we've cited in paragraph 23, Lord Bingham said, "The basic task of the court is to ascertain and give effect to the true meaning of what Parliament has said in the enactment to be construed. But that is not to say that attention should be confined and a literal interpretation given to the particular provisions which give rise to difficulty. Such approach not only encourages immense prolixity in drafting, since the draftsman will feel obliged to provide expressly for every contingency which may possibly arise." So we suggest those are particularly pertinent passages in the authorities that we ask the board to bear in mind, since we suggest that the appellant's case on section 23 is essentially an overly literal textual argument seeking to distinguish between the words void and unenforceable, rather than focusing on what was actually Parliament's intention in enacting section 23. So that's our first point. The second is to show the board the decisions below, because as already mentioned, the board wasn't actually taken to decisions by my learned friend. And we've summarised the decisions in our written case at paragraph 80, so that's in the key documents bundle at page 655. And we see at paragraph 80, we have cited the decision of Murphy J. in Esso, which I will take you to now. So that is in the bundle at page 1565. And it's within this judgment I can help answer my Lord Ree's question about whether the decision of Knox J. in Chase Manhattan can be distinguished. So we start at page 1565, and we see at line 22 that Murphy J. refers to LCCA. He describes it as the saving provision. He quotes it, and it's then said, "It is argued that the legislatively purposely excluded unenforceable contracts from the scope of this saving provision." So that's essentially the same argument that's now levelled against us. And if we go over leaf at page 1566, further down on page 1565, we see that the party seeking to rely upon that argument that void is to be contrasted to enforceability had relied upon Chase Manhattan. We see that at the bottom of 1565. And then we see at page 1566 at line 6, Murphy J. says, "Knox J. was clearly concerned about giving effect to what amounted to a fraud and found the contract to be unenforceable on the narrow and, in my respectful view, quite unsatisfactory ground that the transaction had not yet been executed, so that no transaction on the stock exchange would need to be unwound. This was regarded as the policy reason for the omission of unenforceable transactions from the saving provision." And we then see at line 17 or 18, "I believe that section 23 was intended by the legislature to save all transactions entered into by companies which might have been in breach of section 4 of LCCA. It could not mean anything else. It is expressed to be for the avoidance of doubt, and that is with a view to avoiding commercial contractual chaos. The term unenforceable has been loosely used in the authorities on the legality of contracts. Contracts may be void for illegality and thus unenforceable as a matter of cause and effect. But there can be a class of unenforceable contracts distinct from void contracts. The difference involves procedural considerations. And then we then turn over leaf to 1567, and we see at line 33, in any case, for the reasons given above, I conclude that if there was illegality, Section 23 was applicable to save the agreements. So to suggest otherwise would be to stretch the precedents beyond reason and to pass from reality into formalism and make-believe. So we see that Murphy J really gave this argument short shrift and found it was not compatible with the purpose of the legislation. So that's the decision of Murphy J on Section 23. We then have the decision of the Court of Appeal on this point in ESSO at 1585. In the middle of the page at 1585, it's addressed briefly. We see at line 22, in my view, Section 23 of the Control Law also supports the interpretation the legislature did not intend to prohibit specific contracts made in the course of carrying on business. Arguments may be advanced that transactions which may neither be void or voidable may nonetheless be unenforceable at the instance of the party who has breached the law. Whether this is so or not, the section does not indicate the legislature did not intend to make illegal specific contracts made in the course of carrying on business at a period where there was no license in force. So it's addressed somewhat briefly as compared to Murphy J's decision. And then in the present case, we see the Chief Justice's decision at page 46. At paragraph 83, and we see that the Chief Justice in the present case, having cited Murphy J's decision at paragraph 82 of the Chief Justice's judgment, we see that the Chief Justice follows that reasoning and she concludes at paragraph 94, given the provisions of Section 23, there is little to sustain the argument that a breach of Section 4 renders the loan agreement void, and even less with respect to a breach of TBLA, the only purpose of which is to raise revenue. And then finally, the Court of Appeal's decision in the present case is at page 85. And this is dealt with briefly in the second sentence of 73, page 85. As far as LCCA is concerned, the express provision in Section 23 that no business transaction shall be void or voidable by reason only that any party to it is in breach of LCA appears to preclude the loan being unenforceable at common law. So again, dealt with somewhat briefly.
Could you give me the paragraph number?
Forgive me, it's on page 85, it's paragraph 73,
73.
the last sentence. But the board will have seen that the detailed reasoning on the meaning of Section 23 was addressed by Murphy J at first instance, including with respect to decision in Chase Manhattan. So those are the decisions below, which I've taken rather quickly, because I'd like now to move on to my third point on Section 23, which is about terminology. And this mirrors the point that my Lord Burroughs made this morning, which is that void and unenforceable are used interchangeably in the context of illegality. And in our written case, at paragraphs 30 to 38, so you'll find this in the key documents bundle at tab 4, page 643. What we've sought to do here is to set out the law on illegality as it existed at the date of enactment in 1971. So paragraphs 30 of our written case onwards. And if it's convenient, I'd just like to use my written case. We've given the references to the bundle in the right-hand column of our case. And we see at page 32, we start with citation from Halsbury's Laws of England in its third edition, usefully, the appellant filed yesterday a copy of the supplement as at October 1971, which appears to make no changes to these paragraphs. So together they show what Halsbury's laws regard as the law of England on illegality as at the date of enactment in 1971. And what's interesting is we see from the quote there, in paragraph 32 of our case, we see reference to classes of void contracts. So void is used as a catch-all. We see in the bold text contracts which are expressly prohibited by statute from one of these classes, another class which consists of contracts which are illegal at common law. So this is a description of both what I would refer to as statutory illegality and common law illegality. And we then see in the next paragraph quoted from Halsbury's that as to common law, in the bolded text, an agreement to commit an unlawful act, whether it amounts to indictable offence or not, is void. So Halsbury's is referring to common law illegality having the effect of being void, which is the opposite to what my learned friend tries to suggest is the effect of common law illegality being unenforceability. And we then see in the next paragraph where Halsbury's explain statutory illegality, it refers to a contract made in contravention of the statute is illegal and cannot be enforced. It says in other cases the contract is expressly declared by statute to be void. In a third class of cases, where the mode in which a professional business is to be carried out is regulated by statute, no contract which is made in contravention of the statutory requirements can be enforced. So we see both void and enforceability referred to interchangeably. And what's interesting, as mentioned, is the expression void is used as the effect for common law illegality. This may, of course, reflect the fact that the law was confused in 1971. We do have a useful report of the New Zealand Contracts and Commercial Law Reform Committee, which is in the bundle at page 4623. And this was the predecessor to the New Zealand Law Commission. It was chaired by a QC in New Zealand who later became a judge of the New Zealand Supreme Court, so their High Court. And included on the committee were 2 New Zealand academics. And we see at page 4623, beginning of the report, and then we see at page 4629, the New Zealand committee explain what I've described as statutory illegality. And at page 8 on 4629, the committee explained the authorities that then existed. And we're looking here at the report in October 1969, so very close to when the statutes were enacted in 1971. And the committee explained that there were various effects of statutory illegality. One was that neither party can enforce the contract. The second was also that neither party can enforce the contract. The third was that sometimes one or sometimes both would be unable to enforce it. The fourth was that one party could enforce it, and the fifth was that both parties could enforce it. And we see at paragraph 9 that statutory illegality gives rise to 2 major difficulties. The first is that it's often very difficult to know in which of the above 5 categories a particular case should fall. And we see down the bottom of 4631, at paragraph 11, the committee had then explained the consequence of illegality, both for common law illegality and statutory illegality. And they say that ordinarily neither party to a legal contract can enforce it. Then over leaf, at page 4632, the committee say illegal contracts are frequently described as being void. There is room for argument whether this is in fact so. So we suggest that does show that the law was somewhat complicated in 1971 and in an unsatisfactory state. And in fact, this report of the New Zealand Committee led to the New Zealand Parliament passing a statute to reform the law called the Illegal Contracts Act of 1970. And then if we move now to the present position under English law, we've referred to in our written case at paragraph 107 to the decision of the English Court of Appeal in Ocadina, and this is in the key documents bundle in tab 4 at page 663. So our written case at paragraph 107, and if it pleases the board, just to show you this passage in the case rather than in the judgment, we see that Lord Justice Underhill stated, "I start with a point about terminology, having referred to my Lord Borough's textbook for a statement of the law of contracts. The language of prohibiting the contract is found in several of the authorities, but other language is also used, including whether the contract is illegal or forbidden, or whether there is an intention to nullify the contract or render it void. These are all expressions of the same concept, namely that the statute intends to deprive the contract of any legal effect, with the result, reverting to Professor Burroughs' phraseology, that it is unenforceable by either party." So the view of Lord Justice Underhill in Ocadina was that the expressions void or unenforceable are used interchangeably in the authorities on illegality. And this decision, Ocadina, was later approved by the Supreme Court in Henderson and Dorset. And finally, on this point, is the passage from Chitty on contracts, which we cite in footnote 40. Footnote 40 cites Chitty, well, in fact, it's cited earlier up in the passage of the text, but footnote 40 is where we give the detail. That Chitty at 1907-078 is making the distinction between where the contract is forbidden by statute, just to note that correction in footnote 40. And it then says, however, this is at Chitty in footnote 395, however, the more recent authorities on this point is put in terms as to whether the statute renders the contract unenforceable by either party, rather than whether it can be avoided ab initio. So that's the modern approach to refer to unenforceability, not void. So we would suggest that the historical commentary, both from the New Zealand Law Committee and from Holsbury, supports the proposition that at the time of enactment, void and unenforceable were used interchangeably, and therefore one cannot presume that the Cayman Parliament was seeking to distinguish between those terms. The fact they refer to void is a synonym for unenforceable. That's our third point. The fourth point is a related point, which is that where the court found that there was no implied or express prohibition on the contract, what I've described as statutory illegality, that occupied the field. So the courts did not then go on, if they found that the provision did not impliedly prohibit the contract, they did not then go on to consider common law illegality, as you are now invited to do. And we can see that, firstly, from the passages in Holsbury's that I've shown you, and the New Zealand Committee's report, that they essentially treat the different classes of illegality as separate and distinct. There's no suggestion in the text I've shown you that you start with statutory illegality and then move on to deal with common law illegality, as the modern law would suggest. And this was the fact pattern in the cases as at 1971. And we can see that from the important article of Professor Michael Firmston, who was a scholar of contract law in England, which we cite in a written case at paragraph 34. So at the bottom of page 644, at paragraph 34 of our case, we cite Professor Firmston's article, Analysis of Illegal Contracts, which is in the bundle starting at 4642, but we've included the quote here. Surprisingly, despite the enormous contemporary proliferation of statutory offences, there is very little authority on this point. Cases involving the point are usually treated either as a case of illegal performance or of statutory illegality. The difference between statutory and common law illegality is very important in this context and can very easily be the subject of confusion. And then moving down to the next emphasised text, this should mean that where you have a contract to do X and X is the subject of statutory prohibition, the court should usually consider first whether the statutory prohibition impliedly prohibits the making of the contract to do X, and secondly, whether an agreement to X is illegal at common law principles as being an agreement to commit a crime. In practice, however, in this type of case, the courts usually concentrate on the first question, that is, whether the contract itself has been expressly or impliedly prohibited. Where, as is often the case, the statute is silent, this is a difficult question. It is difficult to understand why, where, as is usually the case, the act in question is technically a crime, the alternative argument is not considered. So the professors explained that ordinarily the court simply started and considered, does the statute expressly or impliedly prohibit the contract? If they decide it did not, that's the end of the matter. And that would also explain why in the present circumstances, Section 23 does not need to go on and declare that common law illegality does not need to be considered, because the starting point is if you exclude statutory illegality as I've described it, you don't need to go on to consider common law illegality. And that was the position in 1971.
Yes, and that's the position that the Court of Appeal took in the present case so far as the LCCA was concerned, because you have Section 23, but in relation to the TVLA, where the statute is silent, they took the view that they had to look at the Patel and Mirza approach, but it didn't take them very long to come to a view about it.
It didn't, my lord, because as I'll come to show you, there is a huge overlap, if not entire overlap, between the considerations when you're looking at the statute compared to common law illegality. And I will show you the decision in due course that in the present case, you should not go on to consider common law illegality because there's no knowledge on our part that we were in breach of the legislative requirement. So our final point on Section 23, subject to what I can consider your lordships and lady with, is on the question of settled position in the law. And we set this up in our written case at paragraph 25, which is page 642 of the bundle. And we see we've cited the recent decision of the Supreme Court in Wathan Fayed. The full reference is overleaf at page 641, paragraph 22. And at paragraph 62 and 66 of Wathan Fayed, Lord Hamble referred to the issue of settled practice, principle which Benyon describes as being where the meaning of a statute has been considered by the lower courts and business or other activities has been ordered on that basis for a significant period of time, courts may be slow to overturn settled practice and understanding. I've set out in the rest of our written case at paragraph 25 onwards that the law is not entirely clear on this point. What Lord Hambling concluded, which we've cited at paragraph 26 of our case, is that if there is such a principle, there is much to be said for the view that its relevance is limited to providing evidence that the statutory words are capable of conveying the settled meaning and that the meaning is workable in practice. What was not referenced by the Supreme Court and Wathan Fayed is the decision of this board in the Promeo Fund decision, which my learned friend referred to briefly, a decision where the board found that the decision of the English Court of Appeal Investor and Butcher had been correctly decided. And we see overleaf in our written case at page 643, at the top of 643, the board said a further consideration to which the board attaches considerable importance is the fact that Vester and Butcher has been accepted as settled law for some 35 years, both in England and Wales and a number of other common law jurisdictions. Throughout the period, contracting parties, both in the area of provision of professional services and more generally, negotiated and contracted on the basis that there may arise concurrent claims in contract and in the tort of negligence. Contributed negligence will arise in defence. In other words, Vester and Butcher had been settled law for 35 years and the board was going to be slow to depart from it. So those are the legal principles. In our written case, going forward to 118, we make the point based on those authorities that the decision in Esso of the Cayman Court of Appeal has been long-standing authority now for 25 years. It has been settled law. There has been no criticism identified in the authorities or by commentators in that period. And no doubt many counterparties would have entered into contracts which would otherwise be vulnerable if SO was overturned. So obviously we put some additional points in the written submissions, but those are our arguments on section 23. They're obviously a mixture of both some textual points. They also go to the historical background that existed at the time in enactment in 1971. What I haven't taken you to so far is what we put in our written case at paragraph 100, which is on page 661, which is an attempt to try to have a close textual reading of all of the words in the provision. I started off by referring to the words "for the avoidance of doubt, it is hereby declared." That's where you find those arguments in our written case. And the further point that I haven't made yet is at paragraph 101 and 102, which is linked to the law I took you to earlier about the need to make sure that statutes can be understood by the citizens of the country. And we make the point at 102 that this statute was of course intended to affect directors, business persons overseas that want to undertake business in the Cayman Islands. So we make the simple point that therefore this is not a technical statute. The statute must be understandable by the businessman or woman, and that the overly textual approach, a nuanced approach that void means a certain type of contractual effect, we suggest would not be understood by the normal business person.
My understanding is that your submission is section 23 disposes of the LCCA illegality, and without more. There is no section 23 equivalent in the other statute. But I understand you to be relying upon what Lord Leggatt said at page 3007, paragraph 83, and that it's incongruous to have a situation where it's accepted that there is no statutory illegality insofar as it was neither expressly or implicitly by statute provided that the contract is unenforceable, and yet you have common law illegality, and Lord Leggatt relies upon there has to be an additional factor which might justify a conclusion. And you say there's no additional factor in this case, if I understand your argument correctly.
My Lord, exactly. That is our main point on common law illegality.
In relation,
that would apply both for section for TBLA
yes, it would.
and for LCCA in the event you ruled against us on section 23. But essentially, that's our main point.
Yeah.
But there is a formal point, which is that my learned friend sought to link the policy and purposes of TBLA with LCCA in his submissions. Yeah. He suggested that because to get a license under TBLA, you need to have a license under LCCA, you should read those statutes together. And if that is correct, and I can understand the force in that, they were enacted at the same time, within days of each other, then that would suggest the board should look at whether you should read the statutes together. Section 23 of LCCA, of course, is very clear. Why would Parliament intend a different outcome for potentially illegal contracts under TBLA as compared to LCCA? Particularly given that LCCA has a narrower effect than TBLA. TBLA applies to every Caymanian-owned business that falls within the remit of the statute. They all have to apply for the license under TBLA. So that's a very broad application. It would be very surprising if the Cayman Parliament intended to make unenforceable all the contracts entered into by the Caymanians as well as non-Caymanian-owned businesses that are otherwise required to have licenses under TBLA. So the final point on section 23 is just to draw together submissions I've made already on the purpose of the statutes. And we see that in our written case at paragraph 109, at the bottom of 663, we suggest that the board should also consider the purpose of the statute as a whole. And we've already made those points, that the courts have found that the purpose of the statute was not to regulate the commercial activities and contractual relations of the parties. It was simply to impose this licensing requirement. And that falls in alignment with the other points regarding the interpretation of Section 23. There simply is no reason why the Caymanian Parliament would intend to, through Section 23, leave open the possibility of common law illegality, be contrary to the underlying purpose of the statutes, as well as the other points I've made. So unless I can assist you further, those are the points on Section 23. So if I move now to common law illegality, which we have, through my Lord Stephen's point, started to move on to. Now, as has already been discussed, if we succeed on Section 23, in other words, if the board finds that the lower courts did not err in their interpretation on Section 23, that is fatal to the appellant's case on common law illegality, at least as to LCCA. I think that much is accepted by them. We've made the point regarding TBLA being read in conjunction with LCCA. If I can now turn to our three main submissions on common law illegality. And the simple question, which goes to my Lord Stephen's point, is how can there be common law illegality when there's no statutory illegality? So the appellant now accepts that Parliament did not expressly or impliedly seek to prohibit or make illegal the contracts, even if the licensing requirement was breached. Those statutes contain their own punishment mechanism, criminal offences, and it's difficult to see why the integrity of the legal system would be harmed by enforcing a contract in that scenario. And that, of course, is the test under Patel and Mercer. And we suggest that the critical failure in the appellant's case is they have not identified why the legal system would be harmed in that scenario, where Parliament did not intend to prohibit contracts. And that simple proposition as to why there would be common law illegality in these circumstances is answered by the board's decision that we've just been referred to in SR Projects and Rampasad. And if I can just take you to that page which my Lord Stephens was referring me to, which is page 3007. So in this judgment of the board, we see at page 3007, at paragraph 82, that the board concludes that the Act and regulations cannot be interpreted as providing that a contract under which a loan or deposit is received, etc., is void or unenforceable by the lender or depositor. So no statutory illegality, as I would describe it by that shorthand. And they go on then to deal with public interest. So this is the heading for common law illegality. And Lord Legate says, in circumstances where the applicable legislation could have provided, but does not provide expressly or impliedly, that a breach of the regulation shall have the effect of making a contract relating to a loan received by a society in excess of its maximum liability void or unenforceable, it is difficult to see how allowing enforcement of such a contract could be said without some further factor to be harmful to the integrity of the legal system. The most plausible, if not only additional factor, which might justify such a decision, such a conclusion, would be knowledge on the part of the lender or depositor that it was participating in the commission of an illegal act. This is the approach taken, for example, in relation to employment contracts, see Ocadina. And then Lord Legate goes on at paragraph 84 to say, there is, however, no finding of knowing participation in this case. Overleaf at page 3008. We see, similar to what my learned friend tried to suggest on his feet at page 85, in their supplemental submissions, counsel for the liquidator described the party's belief as inexplicable and says it's difficult to accept that lender did not knowingly participate in a breach, or at least was willfully blind to the breach. And we see at the bottom of 85, importantly, Lord Legate says, the trial judge made no finding that he did, and there is no basis on which the board could properly conclude that the lender knowingly participated in illegal conduct or did not act in good faith. And we then go on to the passage that I took the board to at the very beginning of my submissions. An overleaf at page 3009, paragraph 88 and 3009, we see the conclusion of the board. In sum, it cannot, in the board's opinion, be said that allowing a lender to enforce a loan agreement made and security accepted by the lender in good faith without knowing that the credit union was borrowing in excess of the legal limit would be harmful to the integrity of the legal system. So Lord Legate applies his proposition that you need an additional factor in order to have common law illegality. And that additional factor was potentially knowledge. There was no knowledge in that scenario. And we suggest in our written case at paragraph 129 that Lord Legate's dicta I've just taken the board to sets out a proposition of general application. Namely, if the court has found there is no statutory illegality, in other words, that Parliament did not expressly or impliedly intend to prohibit the contracts, absent an additional further factor, it would not be harmful to the integrity of the legal system to allow the contract to be enforced. And we suggest that is entirely consistent with the overlap between the considerations the court has when considering statutory illegality as compared to common law illegality. And we cite at the top of page 668 in our case the comment of Underhill LJ in Ocadina. The distinction between those two types of illegality is in truth largely at the level of theory, since the same underlying principles are involved. And we suggest that is why in the Court of Appeal in these proceedings, Beats and J.A.'s analysis of common law illegality could be brief, because he had already considered all of the same factors when dealing with statutory illegality. And what we've done in the written case to apply this point is at paragraph 69 of our written case, 69 to 79, we have set out the findings both in ESSO and in the present proceedings of the three considerations, the trio of considerations, when the courts were dealing with statutory illegality. But you can see here complete overlap with the same considerations the court would apply when dealing with common law illegality under the trio of considerations. So we see page 652 of the bundle at paragraph 69, we've set out the findings on the underlying purpose of the statutes. So that is trio consideration A, which I've already taken the board to at the beginning of my submissions. We see at page 654 at paragraph 74 that the courts below considered the public policy considerations against the finding of illegality. And we then see, which include, of course, public policy concern of upholding contracts, which I took the board to at the beginning, and then overleaf at paragraph 77 onwards, we've summarised the proportionality concerns that the court addressed. So the fact is, the courts below in ESSO and the present proceedings addressed each of the trio considerations when dealing with statutory illegality. And that highlights why the decisions I've cited already mean that you do not need to go on to consider common law illegality unless you have some other factor. And so moving on then to whether there is that additional factor in the present case, we say here there is no such additional factor, the additional factor being potentially knowledge. My learned friend on his feet tried to, for the first time, allege, I say improperly, that the respondent knew that they were in breach of the statute. There's no pleaded case of that at all. And in fact, I can show you such an allegation was also struck out by amendment. So if we go to the bundle at 162, we see in the re-amended statement of case at paragraph 162, at paragraph 168, as it then was in the amended statement of case, what has been struck out by amendment is being guided legally and assisted in carrying out its powers and duties by the law firm Americorp. The defendant knew or should have known that it needed to be duly licensed as a commercial mortgage lender in the Cayman Islands before it illegally commenced to carry on and to continue carrying on its local business as such. So there's no allegation of knowledge.
Sorry, I do apologise. 162, paragraph what, sorry?
Paragraph 168.
168. Thank you very much indeed. Thank you.
So we see there the original allegation that the respondent knew they were in breach of the requirement was struck out. There simply was no allegation at trial of knowledge. And I suggest it's improper, therefore, for my learned friend in his submissions on his feet to raise yet another case, a new case on appeal. And absent this additional factor of knowledge, applying SR projects, that should be the end of the matter, whether it's applying common law illegality to LCCA or to TBLA, because the board has no appeal against those findings of statutory illegality. They abandon that appeal. And therefore, that is the end, we suggest, of common law illegality in this case. Now, if we're wrong on that, then we carry on to other submissions. The second submission concerns the role of the appellate court when considering an appeal against common law illegality. I'll just deal with this very briefly by giving you the reference to our written case, which is 124. And we see there we've cited the Court of Appeal's decision, which my learned friend referred to, of the then Chancellor in Singularis Holdings, where the Chancellor said that an appellate court, when considering an appeal against common law illegality, must either, to overturn it, decide that the lower court proceeded on an erroneous legal basis or took into account irrelevant factors or failed to take into account relevant factors. And I mentioned at 126 that Baroness Hell reserved the Supreme Court's position on that point, but she did not express any criticism of it, she just reserved the point. Now we suggest applying that, however, that my learned friend has got nowhere towards showing that there was an erroneous legal basis. We can see from the passages I've showed you that the courts below properly referred to and applied Patel and Mirza, and that should suggest the court should have great caution in seeking to overturn any decision on common law illegality. Then moving on, our third point is then the application of Patel and Mirza, if we ever get to this point, which on our first two submissions the board should not get to. Again, the board has not been taken to the findings below on this, and I'm not sure whether I have time to do so, but if I can just quickly take the board first to the decision of the Chief Justice, which is in the bundle at page 49. And we see at page 49 at paragraph 99, the Chief Justice has already, of course, found that illegality does not arise, including because of section 23, but nonetheless at 99 goes on to consider common law illegality. And the judge refers to the decision over leaf at paragraph 100 of the Court of Appeal in Esso. She refers at 101 to the decision in Patel and the need to apply the trio of considerations. And then at 103, the Chief Justice adopts the submission that trio of considerations B and C are about whether, taken together, the regime for registering local businesses by invalidating contracts is inherently in contradiction with the public policy promoting validity of contracts. So that's the key point I made at the outset of my submissions. And what the judge concludes at 104 is, applying Patel, I would hold that the purpose of the licensing regime in LCCA is not undermined by enforcing contracts made in breach of its positions. As George's JA observed at page 314, the objective of the licensing regime can be effectively achieved by laying charges against the entities which infringe the law and imposing fines calculated on the basis of a number of days during which the infringement occurs. I think that was the point my Lord Reed made to me earlier, that you can use the existence of the criminal sanctions as a reason why common law legality should not apply. So that's the conclusion of the judge, albeit expressed briefly, but as I've shown, there was overlap between the considerations between both common law illegality and statutory illegality. And then the Cayman Court of Appeal addressed the issue briefly. We can see that at page 85. And at page 85, at paragraph 74, the point has been made to me that the Court of Appeal just dealt with common law illegality for TBLA. And to start with, we see the Court of Appeal refers in the second sentence to the reluctance of courts to invalidate contracts made by parties who do not have the licence required by TBLA and LCCA when considering whether there is an implied statutory provision. And then refers back to paragraph 57 to 61, emphasising the crossover between the different considerations here. The fact is, I have considered in that context, that is the context of statutory illegality, include the purpose of the statute in question, relevant policies, and whether invalidating contracts would have wide consequences. Those factors are very similar to Lord Tolson's trio of necessary considerations under Patel and Mercer. And then, very briefly, the judge goes on at the end of paragraph 74 to say, I consider that the trio of necessary considerations have a similar relevance in determining the enforceability of a contract at common law, and that applying them to the loan contract produces the same result. So it is a very brief analysis as to why there's no common law illegality. But as I've shown you, there's a complete overlap in the factors, the three factors that the court has to consider under common law illegality. So we suggest, albeit common law illegality is dealt with briefly, that there's no basis on which to say that the lower courts erred in finding that there was no common law illegality, particularly because there is no additional factor. And there's certainly no finding, let alone allegation, of knowledge on the part of the respondent. As I said, I think that submission was improperly made for the first time on his feet this afternoon. So I think I have probably covered the key points on common law illegality. Of course, they're satisfied in our written case if you want further detail on page 666 at paragraphs 1 to 1 onwards. And we see the final point, which I have not yet covered under this heading, is addressed at paragraph 135 of our submissions at page 669. And what we've addressed here is the purpose of the statutes, which I've already addressed the board on orally. And we suggest that there's no basis to use some potentially wider purpose Mellon and Fenn relies upon, that there is some form of active regulation under the statutes. My Lords, I think I've covered the points you asked me to, but I wonder if I can take a moment just to check my notes. And of course, I will be here to answer any questions. some of the points rather a lick, expecting I had to leave some time at the end
Yes.
for the other issues. Obviously, there are a number of points on POCA we would have made. I'm in your hands. The other point which we haven't addressed so far is the question of the leave to appeal test, which of
Oh,
course,
yes.
which is a point of general importance. And I wonder if
Yes.
it's worth me using some of my time to address you on.
Yes. Mr. Raw, I don't think really had time to deal with it, but it is addressed obviously in a written.
Exactly, but it is a point of general importance.
Yes.
for the Cayman Islands.
Yes. So by all means, we do have time for you to address us on that.
I'm great. I think I've got 20 minutes, which I won't need to use all of, but I'll just use some of it if I may.
Yes.
So this is in our written case.
It's 682.
I'm grateful, my lord, yes. And it's difficult to work out entirely the criticism that's made against the Court of Appeal here, because of course, in one sense, their second ruling, which concerned leave to appeal, is academic now. But I think the main point that's made on this appeal is whether they got the test correct,
Yes.
and whether in potentially misapplying the test, that's something that the board should be correcting at this stage. It is academic, of course, but you will have seen that the Cayman Court of Appeal issued a separate judgment on this point.
Yeah.
I don't know if my lords have had a chance to read that. That is
Yep.
in the... I'm grateful. So if I can just start then...
I mean, the critical question is a genuinely disputable issue the same as a finding the finding that there's no genuinely disputable issue the same as a finding that there's absolutely no merit?
Exactly, my lord. And essentially what's been put against me, if this was a live appeal in which you were still determining special leave to appeal, was that they've gone too far in assessing the merits of the case, and that they've failed to appreciate that there is a very low threshold. But that's an irrelevant point now, because the board granted special leave to appeal. The only issue of general importance did the Court of Appeal apply the correct test? So what is the correct test? Forgive me. And we suggest the correct test is that set out by the board in its previous decision in A versus R, which is a decision of the Privy Council 2018 UKPC, that leave can be refused where there is no genuinely disputable issue arising on the proposed appeal.
Well, speaking for myself, I think that's just a synonym for devoid of merit.
My lord, yes, or no prospect of success,
Yes.
or any other term along those lines. What's more difficult to understand is how abuse of process would necessarily be a synonym for no prospect of success, because they might be different.
Yes.
We suggest that the key to determine this, and with respect to the board's previous decisions, I'm not sure was properly grappled, is this is a question of statutory interpretation of the relevant jurisdiction governing leave to appeal to the Privy Council. And that, of course, for the Cayman Islands, we refer to at 198, is the Cayman Islands Appeals to the Privy Council Order 1984, which my lords will find in the bundle at 624. That's not quite the right reference, is it? 761. And we see at 761, under the 1984 order, we see, just to take it in turn, at section 2,
So what's the page number again? Sorry.
it is 761.
Okay.
And I think there may have been some amendments to the 1984 order since, and what you may have here is the original version, but I don't think anything has been amended that's critical to this point. But we see it at Order 2. Appeal means appeal from a decision of the court to Her Majesty in Council. So that's an important word we suggest in the order. And we then go on over leaf at 762. Subject to the provisions of this order, an appeal shall lie as of right from decisions of the court to Her Majesty in Council in the following cases. So we suggest that the two key words here are an appeal, obviously, and the next important words are as of right. And then in due course, we see at Regulation 4 or Order 4, applications to the court for leave to appeal shall be made by motion or petition within 21 days of the date of decision, and the applicant shall give notice to the other parties of his intended application. So I will go on to explain some of the textual points here, but that's the key parts of the 1984 order that the board needs to construe, and they are relatively straightforward. In our written case at paragraph 200, we set out a number of decisions that the board has reached in other jurisdictions. So this is page 683 of the bundle, paragraph 200. And we start with a decision of the board in a case coming from Trinidad and Tobago, which is Elaine Forte. And this is in the bundle at page 779. And what Lord Nichols said in the decision at page 73C internally was that an appeal as of right by definition means that the Court of Appeal has no discretion to exercise. All that is required, is that the proposed appeal raises a genuinely disputable issue in the prescribed category of case. So it is fair to say that the word genuinely disputable does not expressly fall within the words of the 1984 order. And then if we go on our written case to paragraph 200B, there is a similar decision of the board in a case from Guernsey in A against R, which is in the bundle at page 1762. And we see at paragraph 8 in Lord Hodges' decision there that the board says an appellant's appeal as of right does not mean the Court of Appeal has no control over the appeal. Orders in council in many jurisdictions with appeals as of right provide for the appellate court to grant final leave to appeal only after the appellant has provided security for costs and complied with other prescribed procedural conditions. More generally, the Court of Appeal has power to make sure that there is a genuinely disputable issue within the category of cases which are given an appeal as of right. And then Lord Hodge goes on to cite the paragraph I just cited from Elaine Forte, Lord Nichols. And then finally, to complete the trio of cases, at paragraph 200C of our written case, we cite Mayor against Baines, a decision of the board from Antigua and Barbuda, which is at page 2318. And we see at 2318, at paragraph 22, Lord Kitchen, having cited the same decisions that I've referenced of A against R and Elaine Forte, says that the board considers that this reasoning is also applicable to appeals from the Court of Appeal of the Eastern Caribbean Supreme Court, but the Court of Appeal has a right to police applications of this kind and to consider whether any proposed appeal raises a genuinely disputable issue. And then we then see, he goes on to say, in this case, the Court of Appeal exercised that right, refused leave to appeal and dismissed the application. In so doing, it did not exceed its jurisdiction and made no error in approaching the application in the way that it did. And of course, those are all decisions of the board in different jurisdictions under different pieces of second legislation, albeit all falling under the 1833 and 1844 Act. But we do suggest they're instructive as to how the board should interpret the Cayman legislation, the 1984 order. There is one further authority we cited in our written case at paragraph 201, and that's the decision of Rabsico, Inc. and Prassard, which is the decision of the Cayman Court of Appeal in another case, and that's can be found at page 1751. And Justice of Appeal Burt at paragraph 4 held that the circumstances in which an appellate court can refuse leave to appeal to the Privy Council where such an appeal lies as of right by statute are extremely limited. As the Privy Council pointed out in R and A and R, it may only do so where there is no genuinely disputable issue. That is a very low threshold, bearing in mind there is a statutory appeal as of right. Obviously, we're not trying to argue against any of these propositions because a leave has been granted. We're just trying to make sure the board has all of the dicta relevant to this point. And then if we look then at the decision of the Cayman Islands Court of Appeal in the present case, we see they've cited a number of these decisions. We can see that this is in the key documents bundle at tab 8, at page 90. And we see referenced by Beetson J.A. the fact they've handed down the decision dismissing the... And we see note in paragraph 91, in paragraph 3 and 4 and 5, to the grounds of appeal that the appellant set out. Notably, nowhere in those grounds of appeal advanced to the Court of Appeal was reference to POCA. It didn't, when seeking leave from the board, assert their new case on POCA, which I'll come back to in due course, because we say it's relevant to abuse of process. And we see there that at paragraph 7 on page 92, the board, so the Court of Appeal considers that this is as of right. And at the bottom of paragraph 7, the Court of Appeal refers to the fact that it remains the case that the court can nonetheless refuse leave. It relies on the decision of the board in A against R, which of course I've taken you to already. Then overleaf at paragraph 8, the top of 93, the Court of Appeal explained the decision in A against R, and they reference both the two tests by which an appeal can be refused in terms of leave, both no genuine disputable issue, and then in the middle of the paragraph, the appeal will be an abusive process. They reference the fact that we as a respondent relied upon both of those categories. They also reference the fact that it's still open to the appellant, if leave is refused, to apply directly to the board for special leave, which we suggest is quite an important safeguard here. And then in due course, in the interest of time, I'll just carry on through to paragraph 11. The board will note at paragraph 11 that the Court of Appeal were cognizant that this is not the same as the CPR test for leave to appeal. And at paragraph 12, overleaf at 94, they refer to the Court of Appeal's earlier decision in Rabsco against Brassard. And then, interestingly, at paragraph 13, they refer to the examples of abusive process that the appellate courts would not ordinarily consider appeals against concurrent findings of fact. And they note the decision of the previous Chief Justice Smelly in Ahab against Sard, where there were concurrent findings. And after reviewing those authorities, the Cayman Court of Appeal refused leave to appeal to the board, as did the board. That's the bottom of paragraph 13. And then overleaf, we see reference to whether this is ultimately, the tests are the same, the point my Lord Stevens made to me. And then paragraph 17, is essentially the crux of the matter. The question, therefore, is whether or not this court can properly conclude that the appellant's proposed appeal is devoid of merit and has no prospect of success. To address that question, it is necessary to consider the grounds of appeal that have been advanced. We would suggest that's entirely right. If the court is going to consider whether to grant leave, it has to consider if it suspects or thinks that the appeal has no grounds of, no possible prospect of success, it must go through those grounds of appeal and consider the possible merits. And that's what the Court of Appeal did from paragraphs 18 onwards. Now, I'm not seeking to justify whether they got that decision right as to whether the grounds were devoid of merit, because, of course, the board's granted special leave. But they did, up to that point, I would suggest, set out the correct test.
Now, Mr. Brown,
Yes.
we're going to have to hear Mr. Rule in reply for about 5 minutes, and we've got about 5 minutes left of our hearing time.
I'm grateful. Can I make one brief point? In this situation, had the appellant, as they should have done, put in their grounds of appeal to the Court of Appeal, they were running the POCA point, that would have given the local Court of Appeal the opportunity to say, no, we think that's an abusive process. So we would suggest that does show the benefit of having more than a rubber stamping exercise in terms of leave to appeal from the Cayman Court of Appeal. I did have some further points on leave to appeal, but they're in my written case.
Very well, then. You take it. We'll certainly consider them. Thank you very much, Mr. Brown. Mr. Rule.
My Lord, yes. The first point that was raised was in relation to what is the illegality. I don't ask the court to go to it now, but my response is based on the judge's findings. Paragraphs 42 for example, on page 36 of the bundle, and her findings at paragraph 66. What she was concerned with, the illegality, is the carrying on of business, not the absence of the licence. And in my learned friend's submissions, he didn't draw a distinction. The case law is clear that there is a distinction as to what is the illegality. Second point is about the offence. Again, the same point. The offence in section 4 is the conduct in section 4.1. Carrying on without the licence and the offence provision is the same section, and the learned judge dealt with those. On the question of the facts, obviously there's no appeal against her findings of fact by the respondent, and it's clear that the sixth loan was to Mr. Hawkins. But in any event, you have her findings on the illegality, and we rely on those because they are not distinguishable from the offending. It is not a breach of statute rather than illegality. Second point on settled practice, in fact, one cannot, of course, rely upon that. Otherwise, we would have Tinsley and Milligan still in place rather than change 20 years later, and the respondent couldn't advance a case because it would be advancing on the reliance principle, and the reliance doctrine would shut it out. So clearly things have to be corrected where necessary. There is no freedom to contract unlawfully, of course, and this is an important point in response to my learned friend's submissions. He doesn't distinguish cases where the court is seeking to protect the illegal doer or the innocent party. Rampasad's a key example. Rampasad is a case where the court was seeking to do justice to the innocent party. And on that basis, it is entirely the reverse situation when one looks at the dicta and the court's approach, which was largely based on statutory illegality, where the consequence would be automatic unenforceability for the innocent, that it was clear that the court was trying to avoid that. Paragraphs 83, 89, 84, all dealing with the innocent's lack of knowledge that was there. So having found statute doesn't prohibit it, what was illegal? Without the knowledge that you were participating in the illegality on the part of the innocent person, that's why the court said knowledge was important. Without them actually actively participating in the illegality, there was no reason to bar them from their relief. So it's a complete reverse of this case, and needs to be looked at properly in that way. The knowledge question, my learned friend points to what was said about that earlier. What has not been dealt with is the facts. Knowledge of the facts is what's important. It's been clearly found that Abarbanel was aware of the facts, and not claiming ignorance of the law is not a defence, but there is also no evidence of ignorance of the law. We just don't have any evidence about that, because Abarbanel's evidence, Mr. Barker's statement, page 284, doesn't deal with whether it had knowledge of the licensing regime and decided it didn't need to, or didn't want to, or whether it was otherwise. But knowledge of the facts is what's important, because that's what the authorities repeatedly talk about. When one's looking at the question of unenforceable, the court asked for authorities on that, and I'm not sure that my learned friend gave you any other than references to where courts had talked about other points up until 1971. In fact, there are several authorities that deal with this point that are supportive of Knox J's interpretation. The first is Lord Justice Diplock in the Hardy Motor Insurers Bureau case, where he drew a distinction with what we would now understand as common law illegality, the ex turpi causa. You can see that quoted by Lord Toulson at paragraph 102 on page 2385. So Hardy and the Motor Insurers Bureau. Secondly, Archbold's. Unfortunately, that case has not been properly put into the bundle, so we have alternative copies. We emailed them yesterday, they may not have reached you. I have hard copies here, which I can hand up if necessary, if that's helpful, but otherwise you'll receive it electronically. It's in our bundle, but it's not copied, so there's only one page of it rather than the entire authority. But it's a case which deals with the question of the effect. Lord Justice Pearce in that case, it's a 1961 case, talking about the difference if one has statutory illegality or one talks about contracts that are not to be enforced by one party rather than both. So the relevant pages in the internal pagination are page 386 and page 388 in particular, Lord Justice Dervlin as well as Lord Justice Pearce, particularly dealing with that. That supports that there's a difference between void and enforcement understood by 1971, as does the case of the
we have that in. We've received the full copy.
I'm grateful. I'm grateful. So you have the references there, and I pray that case in aid of an example of differentiating in the law prior to 1971 unenforceable by one party, typically with common law principles coming in, or void, which was the statutory illegality consequence. I accept the language is now more modern, and Ocadina is a good example. But even in Ocadina, one can see that Lord Justice Underhill was talking differently about statutory illegality causing unenforceability by both parties, or unenforceable by one party based on common law principles. Page 2540, paragraph 16 of Ocadina. So when he uses unenforceable by both parties, that equates to void as it was understood rather than unenforceable by one. But the concept of unenforceable existed in the law when Parliament chose Section 23's wording, the LCCA.
Now, you're going to have to bring your reply to a close very quickly, Mr. Rule.
The fourth example is the Esso Court of Appeal case, which didn't say that Section 23 ousted unenforceability questions. It expressly deals with that, page 1585, lines 28 to 36. So you have several examples there of the interpretation of Knox J being in consistency with understanding of earlier authorities that deal with that. And so far as the courts below approach is concerned, I should say the Firmston article as well also talks about contract to commit a crime and doesn't deal with any of the particular examples that are relevant here, because it's expressly aimed at something else. If the courts below are wrong, as we submit they are, about the effect of Section 23 to essentially leave common law illegality out of consideration, then the Henderson approach of saying statutes dealt with it, we're not dealing with it, clearly is an error, and it didn't deal with matters as Patel and Mirza inquiry requires. And last thing I'll say then, my Lord, is in relation to the Court of Appeal's test for appeal, the concern that we raise is that it's from its own decision, a court is being asked whether there's a real prospect of success. But that's a very different test we submit than the Constitution, and what the court said it was doing was adopting this court's approach for when a case has been wrongly deprived of permission of that leave to appeal when it had a right. The reason this court can do that, of course, is it's appeal to this court. It's in a second opinion constitutionally by this court as the final court of appeal, considering that right of appeal and considering if it's a case with no prospect of success, this court would not wish to entertain it. But that's a different matter for the local court to take upon itself its own view of its own judgment and whether there's a real prospect of success. And we do submit there is a difference in asking whether there's a genuinely disputable issue, which is much more akin to avoiding abusive appeals launched for other reasons. And from Sicker's judgment, you'll see that it identifies expressly that none of those established abuse situations arise in this case. So they understood they were going differently. Paragraphs 15 and 25, they understood that they were adopting a prospects of success test and accordingly regarded it as no genuine disputable issue. But didn't we approach things in the correct terminology, which is important because there'll be cases where it makes a difference to which side of the line it goes. My Lords, I appreciate I'm out of time, so I have nothing further unless you have something.
I don't think so. Thank you very much, Mr. Rule. We're grateful to you and to Mr. Brown and for all those who've assisted you both. We'll now take time to consider your submissions and decide on the advice that we will tender to His Majesty. Court will adjourn.